Hello, everyone, and welcome to this afternoon's presentation by Hendricks Wealth and Estate Management. The topic for today is how do trusts actually work? And I'm joined by a couple of my colleagues, Jim Hendricks, Jim Madel, Dan Leitner, and Tom Anderson. I am your host for today. My name is Sean Hendricks. And just so you know that I'm qualified to talk a little bit about this subject, I am a licensed attorney. I have a license to be a professional financial advisor. And as I correctly predicted 3 weeks ago, I have not yet gotten a Valentine's Day gift for my wife. Hopefully she's not watching this. So for the topic today, trusts can be a really big topic, and it could take a lot more time than we have today. So I wanted to break down the topic kind of like a college level course framework, where we're going to talk a little bit about some foundational stuff, Trusts 101, what is a trust? Then we're going to get into Trusts 201 and talk about different types of trusts. Then in the more advanced levels, we're going to talk in Trust 301 about how trusts function. And then finally, at the advanced level class, Trusts 401 are strategic uses of trusts. So we're going to cover all that stuff today just during lunch. So hopefully by the end of lunch, you guys will feel like you've completed at least a year of law school. But starting with Trust 101. So what is a trust? So there's the legal definition of a trust, which might be great for lawyers, but the legal definition says that a trust is a property interest where one person, the trustee, holds title to the property for the benefit of another person, the beneficiary, arising from confidence or obligation to use the property as directed by the creator of the trust, the grantor or the settlor, for a lawful purpose. That's awful. That's why nobody likes lawyers. I prefer plain English. Plain English is a trust is a document that creates a separate legal entity with the purpose of holding property for you or someone else. Now, even that doesn't make a whole lot of sense until we try to put some substance to it. So my favorite analogy when I'm talking about trusts or what is a trust, to say that a trust is like a boat. So if you imagine that a trust is like a big imaginary boat or a barge that you build while you're living to hold property for you. So you put property on the boat or in the trust while you're living, and then you name someone. It could be yourself or it might not be yourself, to act as the captain of the boat or the quote, the trustee of the trust. The trustee is then responsible for the property in the trust, just like the captain is responsible for the property on the boat. So now that we understand what trusts are, that they're legal entities that hold property for us, we can talk a little bit more about the different types of trusts. And this is the beginning of Trusts 201. And there are generally two different types of trusts, revocable or irrevocable. And a revocable trust is a trust where the grantor or the creator of the trust retains ownership and control of all the assets in the trust, so that the person who creates the trust, they can revoke it or amend it during their lifetime, and that's why they call it a revocable trust. The flip side of that coin is an irrevocable trust, where the grantor or the person who created the trust gives up ownership and control of the assets of the trust. The trust generally can't be revoked or amended by the grantor, except for limited circumstances. It can sometimes be amended by a court or by agreement of beneficiaries, but generally it's called an irrevocable trust because it can't be changed, or it's very, very difficult to change. So even among those two types, revocable and irrevocable, there are some subtypes that you should know. A revocable trust can either be an individual trust, where it's just one grantor or a creator, or trusts allow for joint trusts or joint revocable trusts, where you might have two grantors, and a common example of this is when a married couple creates a trust. Both types can be used, and there's good, compelling reasons to use one or the other. The irrevocable trust type comes in a lot of different flavors. So once you have an irrevocable trust set up, you can have things like an irrevocable life insurance trust, an intentionally defective grantor trust, a grantor retained annuity trust, and you see all those little acronyms there, the ILIT, IDGT, or GRAT, or GRAT. So it's, a lot of times in trust planning, if a trust is irrevocable and you see an acronym like that, you know you're dealing with a certain type of irrevocable trust that's built for a specific purpose. Now, this topic, just talking about trusts, we could spend a lot of time talking about each of those different types. I'm not going to get deep into what those are today, but if you have questions or if you ever want to talk about those things, you can always call us and I can explain them more. Uh, but for the purposes of today, I just want you to know that those different types of irrevocable trusts exist, and they can be used for all sorts of different purposes. Another thing that sometimes comes up, or another descriptive term, is you might hear of a trust referred to as a grantor trust. And when a trust is referred to as a grantor trust, it means that the assets in the trust are treated as the grantor's property for tax purposes. And this can get really important. And the best way I can illustrate this is with an example. So if a trust had 3 beneficiaries, income generated in the trust could either be taxable to the trust, which we generally don't want. That's why it says no in big letters, because trust tax rates can get steep faster than individual tax rates. Income in the trust can also be paid out to the beneficiaries, and therefore it's taxable to the beneficiaries, which this can be a good idea sometimes. There's a lot of good reasons to do this. Or sometimes we want the income to be taxable to the grantor, and there's good reasons to do this too. One of the good reasons to do this is that when income is taxable to the grantor, that money actually stays in the trust. So you've got more stuff staying in the trust when you set it up that way. So this third option can be helpful because it keeps those trust assets in the trust. So we've talked about what trusts are, and we've talked a little bit about the different types of trusts. So now, Trust 301 is how do trusts function? And at the most basic level, the trust holds property during the lifetime of the grantor, right? This is true of both types of trusts. Upon the passing of the grantor or the grantors, if it's a joint trust, the trustee, the person who's now taking over being in charge of the trust, follows the instructions in the trust with respect to what to do with that property in the trust. And when you're talking about the different types of trusts and how they function, it's really the results that you get from either type of trust that are the important distinction to make. So people choose either revocable or irrevocable trusts for different reasons based on the results that they want to get from using either type. So I'd like to give an example of, a fairly common use case for a revocable trust, and then I'll also give a kind of a common use case for an irrevocable trust. So revocable trusts, which are more common, in this example, we have 2 hypothetical people, Bob and Jane. And Bob and Jane set up their joint revocable trust because they're married, and they name their kids as beneficiaries. They transfer their house, all of their tangible personal property, and certain other non-retirement assets into their revocable trust. They use beneficiary designations on retirement assets like IRAs, or other types of assets or accounts that allow beneficiaries like life insurance. So we don't necessarily put everything through the trust. Upon the passing of the second spouse, again, because this is a joint trust, so when the second spouse passes away, the assets in the trust transfer directly to the kids. Assets with named beneficiaries, like the IRAs, transfer directly to the named beneficiaries. So ideally, in this use case, there's little or nothing left to go to probate. And I put probate in big letters there because probate is a process by which a court oversees the administration of an estate. So a lot of times when people are setting up trusts, they're trying to avoid probate. And the reason that trusts avoid probate in the way that they do is because when you set up a trust, you're setting up a legal entity that holds property for you, right? You're doing that in advance before you pass away. So once you've created that legal entity, the trust holds property so that the court doesn't have to step in and create its own legal entity called the estate after you pass away. So probate is important because it's one of the things that we're trying to avoid with a trust, and it can be very costly and it can be very time consuming. So in the next slide, We're going to talk a little bit more about that, but in this example, the results are Bob and Jane's property is distributed to their 3 kids according to the instructions in their trust or according to the beneficiary designations on any assets outside of the trust. And they used the revocable trust to accomplish a few goals. They wanted to avoid probate. Again, that's the legal process where a court oversees estate administration. It's good to avoid probate if you can, because it can be very lengthy and it can be very expensive. A second reason to use a revocable trust is privacy. When you use a trust, at least in Illinois, nothing needs to be filed in court or the public domain. So there's no documents that say, oh, these people just inherited this amount of money. And third, using a trust can be much more efficient. And this kind of goes along with avoiding probate, but a lot of times a motivated trustee can accomplish in a short number of months what it might take the court system a year and a half or longer to do. So avoiding probate, privacy, and efficiency are 3 very compelling reasons that people use trusts. And those are the results that people are typically people are typically looking for when they want to use a revocable trust. So the flip side of the coin now is an irrevocable trust. And the example or the use case here is that, we have hypothetical people, Bill and Sue, who set up an irrevocable trust as part of their estate plan. Because they're using an irrevocable trust, Bill and Sue are giving up ownership and control of the assets that they transfer into that trust. Once the assets are transferred into that irrevocable trust, those assets can, and hopefully will, continue to appreciate in value outside of Bill and Sue's taxable estate. Because Bill and Sue have given up ownership and control, those assets are also protected to the maximum possible extent from creditors. So when Bill and Sue pass away, the assets in the irrevocable trust are managed and distributed according to the instructions in the trust document. And it's their trustee who then follows those instructions. So the results in this use case are that since Bill and Sue gave up ownership and control of the assets in the irrevocable trust, the assets in the trust are not counted as part of their taxable estate for estate tax purposes. This can save a lot of money for their estate if Bill and Sue were above the state or federal estate tax thresholds. So the results here that they were going after, and the reason why they used the irrevocable trust, was because they wanted either to mitigate estate taxes or because they were looking for maximum protection of assets. So those results are the reason that you would want to use an irrevocable trust. So just a little recap. Trusts hold assets while you're living, and they distribute assets after you die. Revocable trusts are primarily to avoid probate, keep things private, and promote efficient administration, while irrevocable trusts keep assets outside of your taxable estate and provide maximum protection of assets from creditors. So now we're getting into the advanced level stuff. So congratulations, we're 3 years through law school right now, and we're about to enter the 401 level classes. And it's how can you use trusts? And there are 2 advanced level trust strategies that I want to talk about. The first is we like to call beneficiary tax planning, and the other is something that I like to refer to as basis swapping. The first option, beneficiary tax planning, is generally used when someone, the grantor or the creator of the trust, creates a revocable living trust and they have multiple beneficiaries in different tax brackets. When that's true, they might be able to save those beneficiaries some significant tax money. So the grantor can direct more pre-tax assets, like traditional IRAs, towards beneficiaries in lower tax brackets, and more after-tax assets, like a Roth IRA, or assets that get a step up in basis, like their home. If they can allocate more of those types of assets towards beneficiaries in higher tax brackets, the result can be that less tax money is owed and everyone gets more money. Now, this strategy really just purposely assigns pre-tax assets towards people in lower tax brackets and it avoids triggering taxes for people in higher tax brackets. So the idea is relatively simple. Do you want assets to be taxed at lower or higher beneficiary tax rates? So the math behind this is a little more complex. So if you're interested in discussing this strategy, I would encourage you to reach out and talk to us, because this is planning that we do for people on a regular basis, and we've seen some really great results from it. The other advanced strategy that I wanted to talk about is what I refer to as basis swapping. And this is used in a scenario where a person has an irrevocable trust. And irrevocable trusts are a little less common, but it's something that can also be a tax strategy that we can use. And so when a grantor sets up an irrevocable trust, the trust can have language in it, and I recommend that the trust have language in it that allows the grantor to swap property in or out of the trust. Now, we already know that the grantor gives up ownership and control of assets in the irrevocable trust, right? But that doesn't mean that the grantor can't swap an equal value in and out of the trust if they want to, as long as this power is included in the trust. So, if the grantor has securities like mutual funds or exchange traded funds or ETFs in the trust, and those securities have gone up significantly in value over time. So let's say the market's done well, and 20 years later, we have some highly appreciated assets in that irrevocable trust. That's great because that appreciation happened outside of the estate. But now we take that even a step further and we say, hey, if the grantor has another asset outside of the trust, and that asset did not have significant capital gains, maybe like a house or some recently purchased securities, the grantor can swap those assets. All right, they can take the asset with low capital gains that's outside of the trust and the asset with high capital gains that's in the trust, and as long as the value is equal, they can swap them. And so when you do that, the reason is because, well, the end game is that it could save beneficiaries a lot in capital gains, but the reason is that the assets that are outside of the irrevocable trust will get a step up in basis after the grantor passes away. So by doing a step up in basis of the highly appreciated assets, you are effectively eliminating the capital gains that might exist for the beneficiaries on those assets. So again, this is more of an advanced strategy, but it is a really great way to potentially reduce or eliminate taxes that would otherwise exist. And this is more for the benefit of the beneficiaries, but when everyone involved can pay less in taxes, that's something that is generally good for everybody. So those are the four different levels: 101, 201, 301, and 401. So I hope you guys got some good use out of that. So we've got a couple of questions that have come in, and the first one says, "Why would anyone get an irrevocable trust?" And anyone is in all caps. The short answer to that question is irrevocable trusts aren't necessarily for everyone. So I wouldn't necessarily recommend that everyone needs an irrevocable trust. But for people who have estate tax concerns, which in Illinois, the estate tax threshold is $4 million. At the federal level, the estate tax threshold is $15 million. For people that have estate tax issues, irrevocable trusts can be a really, really great tool. They can also be a great tool for creditor protection, although that's kind of a less commonly used reason in my experience. So it's not necessarily that I would recommend that everyone get one, but whether or not you need it is a really, really individualized question. And I would encourage anyone who thinks that they might need one to call and talk about it, because if you do use it, there's some really, really interesting stuff that we can do. There's a second question that says, I have a trust but need to change the executor. How much does it take to change the executor? The trust actually has a trustee. If it's a revocable trust, meaning it's a trust that can be amended and changed, it's very easy. Usually it's just has to be in writing and it has to be delivered to the trustee. So one of the great things about trusts, at least revocable trusts, is they're very easy to change. So accomplishing that goal of changing the trustee or the executor would not be very difficult if it's a revocable trust. If it's an irrevocable trust, there may be ways to change that, and that's something that can become a little bit more complex. But usually, when the trust is drafted, we would put multiple trustees in there so that if you needed to change the trustee, it might just be a matter of using someone else who's already named in the document. Uh, so that is an excellent question. Another question just came through. If I'm planning to become an expat in another country and have assets in the U.S., will the trust document still work? With respect to the assets in the U.S., yes, it will. With respect to whether or not the trust will still work in another country, that's a much trickier question. So the trust itself it's at its most basic level, it's like a contract, meaning if it's valid in one state in the United States, it's valid in all 50 states. That's the full faith and credit clause of the Constitution at work. But when it comes to being in another country, it may not work for assets that are held in the other country, but it should still work for the assets that are in the U.S. Excellent question. I don't see any other questions popping up, so I may give it another minute. If Jim or Dan, or if you guys have any other comments that you want to make, please also feel free to take a moment. I still don't see any other ones, so
Yeah.
just as oh, go ahead.
Sean, I was just going to go over exactly what I think you were just going to talk about, and that's the upcoming webinars that we have. Thank you guys all for attending this one. We try to do these every Wednesday at 11:30 Central. And so next week, Dan Leitner, who is, we're all here. So Dan Leitner will be speaking about paying off debt versus investing. Then the following week, on February 18th, Tom Anderson will be speaking to younger investors. So if any of you have any younger investors out there, please get them into this one. It's what to do with your first $10,000 and how to start investing with a smaller amount of money. Some people think you need to wait, and it's not true. The following week, I will be speaking about a topic called the Bank of Mom and Dad and setting financial boundaries. And then the week after that, entering March, Jim Hendricks will be speaking about why you should work with us. So those are the next upcoming sessions. You can go on to hendrickswealth.com and go to the events tab, and there will be a listing of all those there. There's also we record all these webinars, and if you wanted to go back and look at some of the ones we've done in the past, you can go to hendrickswealth.com and go to the resources tab, and then there's a page there dedicated to all of the prior webinars. So, John, looks like a few more questions came in for you.
Yeah, there were a couple questions that just came in. So the first question that came in was, how long does the process take approximately to set up a trust with your company? The answer can vary a little bit just depending on how complex it is. A relatively simple trust, the process might typically take an amount of time measured in weeks if we're starting off with a meeting and then drafting the trust. From the point of time where we start with the initial meeting, get through the drafting, have a final review meeting, that would be a process that's best measured in weeks. An irrevocable trust can be a little bit more complex. So that would have to be something I would have to answer on a case-by-case basis. And then the second question is, are lawyers necessary? Now, please take this with a grain of salt. I'm a lawyer. There's ways to do it without attorneys, but I do not recommend going solo on this or using something that is something that you find online. And again, take it with a grain of salt because I'm an attorney, but trust law gets pretty complex, and it's hard to paint things in very broad strokes or find a one-size-fits-all solution. So I strongly recommend using a lawyer. If you're determined to go down the path where you don't use a lawyer, I would say you kind of do so at your own risk. There are things out there that I've seen, there are trusts that I've seen that come from sources that I have honestly said I did not think it was very well made. So just be very careful. And if you can use a lawyer, I recommend using one.
And Sean,
So
I'll just jump in real quick with just a couple quick comments before we close out. First of all, you did a great job today. It's really nice to see that this was relatively well attended and that you did a great job going through the 101, 201, 301, 401. I think that was all really well laid out. In our practice, both as financial advisors and in Sean's practice as an attorney, we're working very well hand in hand with one another, particularly within the area where Sean talked about with beneficiary designations. Trust assets, when you have a trust, when it's written properly, you can really make the settlement of your estate much more tax efficient, and that's different than it used to be 10 years ago for reasons that I won't get into. It'd be a little complex to get into in 2 minutes. But when you have a properly drafted trust, it does make the administration of the estate from a tax perspective much easier. You don't necessarily save taxes for you today by creating a trust, at least not a revocable trust, but you can save taxes for your heirs quite a bit. And that's something we're working on very extensively in our practice now. So, and Sean, you did a good job explaining all of that and kind of going through the basics of trust here today.
all right, thanks, Jim. I haven't seen any other questions come through. So if there aren't any more questions, I would just encourage everyone, please check out our events page. If you have any questions, you can always call us. The number's written there, or email us at the email address info@hendrickswealth.com. But otherwise, thanks for joining us today, everyone, and we will look forward to hopefully seeing you in some future events in the following weeks. All right. Thanks a lot, everyone.